Okay, next case is Gary Earven versus State of Florida. Both sides ready?
Yes, sir.
You may proceed.
Good morning, and may it please the court. My name is Luke Newman. I represent Gary Earven. I'd like to reserve 2 minutes of my time for rebuttal.
Okay.
Members of the panel, Mr. Earven, as with any other party who comes to this court challenging a ruling on a motion for a judgment of acquittal, when it relates to the sufficiency of the evidence, must allow reasonable inferences in light most favorable to the prevailing party, which would be the state in this case. What I submit to you.
Okay, can I?
Yes, sir.
I'm going to interrupt because
Yes, sir.
you only have 10 minutes, and
Yes, sir.
I'm trying to figure out the duration of the assault,
Yes, sir.
when it started and when it ended. Seems to
Yes,
me
sir.
that's an important consideration in this
Yes, sir.
case. When, in your mind, I know you say there wasn't an assault because he was never put in fear.
Yes, sir.
But let's assume there was a fear element here, just for purposes of this question.
Yes, sir.
When did the imminent threat start, and when did it end?
Judge, I would submit in responding to this question, that the imminent threat would have begun when the handgun was produced from Mr. Earven's pocket and when it was aimed at Mr. Tucker, and then when it was discharged into the air. That those were the acts that were charged as assault in the charging document that were argued to be assault during the course of the trial, and maybe most importantly, were argued to be the assaultive acts during the argument regarding the judgment of acquittal.
Why wasn't it one continuous assault from the time he started yelling at this man and approaching him with his hand in his pocket and was asked, "What is in your pocket?" Why is that not the starting point of the assault?
Because the actions of getting into an argument and being asked in the course of an argument what is in your pocket would not put Mr. Tucker in a position where he would have a well-founded fear of imminent violence. So that I would respond to that by saying the definition.
Isn't that a jury question? You know, if somebody's coming at me yelling and screaming and they got their hand in my pocket, why couldn't that be considered an imminent threat? And why isn't that a jury question?
Because the violence at that point wouldn't be imminent. And then I also want to address your question from the opposite end of the case, Your Honor. I want to point out that the assault had to involve the discharge of a firearm, and it's very important.
And that's why it's important when the assault ended.
Absolutely. It's very legally important in this case based on the way that the case was charged, and the sentence that Mr. Earven eventually received was based on the discharge of the firearm. So arguing that the assault started earlier in the timeline and that this conduct back here in the earlier parts of the timeline was the assault of conduct and not the discharge allows Mr. Earven to effectively serve the enhanced sentence based on conduct that didn't involve a discharge and therefore shouldn't.
Okay, but help me here.
Yes, sir.
Because generally the law when a criminal incident begins and ends is that you look at to see whether there's a temporal break, a location break. Seems this all happened in a very short period of time in one location. So why couldn't it be, and I'm taking the evidence in light most favorable to the state,
Yes, sir.
that was a continuing criminal incident because he was still a threat until he actually drove off?
The assault, but if what you're referring to, Judge, is the confrontation in which Mr. Earven allegedly had the firearm in his pocket and was exchanging words angrily with Mr. Tucker.
What if he'd said, "I got a gun in my pocket"?
No, that was not.
I know,
Oh, right.
what if? Don't miss those two words.
Yes, sir.
What if he said, "I have a gun in my pocket," and started running at him, "You SOB, what you did to my girl"? I'm not saying those are the words that were said, but I'm just trying to figure out exactly when an assault can start.
Judge, I don't think, but those, just to be clear, those aren't the facts. The facts are he was going back and forth with Mr. Tucker.
I concede that.
Yes, sir.
I'm just trying to figure out generally when an assault starts and when it finishes.
That wouldn't have involved the discharge, though, Your Honor. That was what resulted.
I'm getting to the beginning point.
Right.
And
Yes,
it
sir.
could be, it would not involve a discharge, but could involve an assault with a firearm. They're two different questions. I understand the discharge occurred later,
Yes, sir.
so we'll talk about that at the end. But what I'm trying to talk about here is, can we have an assault with a firearm? If I start running at you, and I say to you, that, no, that's not the facts here.
Yes, sir.
I got a gun. You better not talk to my girl again. And I'm coming toward you fast and saying whatever,
Yes,
could
sir.
that be an assault, an aggravated assault?
I think that
And forget the discharge now.
under those facts that you just proffered, Judge, I think that could possibly be an aggravated assault because the difference being in those facts that you just proffered, you say, I've got a gun. In the facts that we have in this case, there
Well,
was,
the question is, didn't this gentleman say he perceived that there was a gun in this man's
he
pocket?
felt, Mr. Tucker testified that he felt that at the time that they were exchanging words angrily,
And
he had a
it in
gun.
fact turned out to be a gun.
That's correct, yes, sir.
Okay.
That's correct.
Well, he in fact testified that he believed it to be a gun, and he felt threatened as a result of that as well. So going back to the kind of the subjective of belief, wasn't there a legitimate threat felt by Mr. Tucker?
I think what Mr. Tucker testified, and his testimony is only a couple pages in the trial transcript, but what he testified to was that the only time that he felt concerned, the only time he felt scared, was when Mr. Earven was talking to him with his hand in his pocket. And what he said was the hand in the pocket was what made him concerned.
Okay,
Because he thought it was a
that's what.
gun.
Sorry.
Because
That's
he
why I'm-
thought there was a gun in his pocket, and he was walking up to him in response to talking to the appellant's girlfriend.
Right, that's correct. Those are the facts of the case. Yes, ma'am. But what he then testified to was that during the discharge and the display of the firearm, subjectively, he had no fear at that point.
Okay, before, I know you're not going to agree with me,
Yes, sir.
but I'm asking a hypothetical.
I might.
If we find the assault started when he started going toward the car, had the gun in his, his hand in his pocket,
Yes, sir.
I know you don't concede, but let's say isn't the testimony that I felt threatened at that time sufficient to determine a well-founded fear? If the assault had already started,
I would
there was
say,
testimony in the record.
as to an assault, I would dispute as to assault with the firearm or as to assault with the discharge.
I understand. I understand that point, but I'm just saying,
But
would that be sufficient testimony of fear? Let's say I had the gun out. I'm trying to find out if his I know we may have a disagreement. We may or may not.
Yes,
I
sir.
mean, I like, up here with hypotheticals, and I'm going to give you more time because I'm talking a lot. But, trying to figure out where the law extends. Let's assume for a second that there was sufficient imminent threat at the time he was walking to the car. Is the testimony, I felt threatened, which is in the record, at that time sufficient to support an assault?
Without a firearm, I would say it's a regular assault at that point. It's not an
Okay,
ag assault.
that's all I'm trying to
Yes, sir.
figure out.
Yes, sir.
So then it becomes critical to this case when the assault started, and for your purposes, with the discharge, when the assault ended.
Because of the way the Florida sentencing law, that's true.
Okay, so let's go to when the assault ended.
Yes, sir.
Once a criminal incident starts, now we're going to get into the case law that I'm talking about. Usually to determine when a criminal incident stops, you look at whether there's a temporal break or a location break or other factors to show, that it's a break. What was the break here?
Those facts were not developed during the record, with the record we have in this case. And the reason is, Judge, and this is in the record, during the JOA argument, that when the state alleged that the assault actually happened earlier, they brought this up and said, Judge, if you go back to his testimony, he said the assault actually happened earlier. We're going to now argue. And that was the trial judge. In this
I don't care what the trial, aren't we here de novo?
Yes,
Don't
sir.
tell me what the trial judge did. I'm trying
Right.
to figure out what the law is.
The state's theory of the case throughout was that the assault happened when the discharge occurred, and we've talked about that before. And that's why it's critical based on Florida sentencing law. But the idea, the concept that the assault actually happened earlier during the interaction was raised and argued during the JOA argument, and it was at that point it was summarily discarded by the trial judge. And so those facts weren't developed. They weren't flushed out during the trial in this case.
So there's no evidence in the record of a temporal break between the time the appellant approached the victim with his hands in his pocket and the time he actually fired the weapon in the air.
Judge, There is no testimony that I'm aware of as to those issues or those facts.
You're down to 19 seconds, but since I peppered you with questions, you never really got to make your argument. I'll give you two minutes on the.
Where I was headed initially, Judge, was I was going to.
Okay, you're now going into your rebuttal time.
Okay, I will cede the rest of my time for rebuttal. Thank you.
Give the state 2 more minutes, please.
Good morning. May it please the state, Frank Xavier Morley on behalf of the state of Florida.
Can you try to speak up a little bit? I'm having trouble hearing.
Okay. It is a well-settled case law in the state of Florida that an aggravated assault for measuring a well-founded fear is an objective, reasonable person standard, and that the victim's subjective feelings are only pertinent in describing a set of circumstances in which a reasonable person.
When did the assault start and when did it end here?
So it's the state's argument that the assault began during the initial confrontation in the front yard with Mr. Earven, where he approached the victim. And if you look at the
When he first stepped out the door? Is that when it started?
no, when he approached the victim in the car with
Do
the
we ever
firearm.
know
in his
how
pocket.
close he got to the car?
I'm sorry, can you repeat
Do
that?
we ever know how close he got to the car?
The record does not indicate that. But if you
Well,
look
if I,
at,
from a half mile away, start growling at you and have my hand in my pocket, is that an imminent threat?
no, not from a half mile, no. But in this case, they were like fairly close together.
How do you know that?
Well, they engaged in a back and forth, and they were within verbal distance. They were speaking back and forth.
Isn't it critical? I mean, I understand your argument about the reasonable man, and we'll get there in a minute. But isn't it critical, because very early in the confrontation is when he said he felt threatened.
Correct, Your Honor. And that's when,
And if I don't know how far he was away from the car, how do I know that was time during the assault?
well, so the victim testified that when he had spoken to the victim's girlfriend, he was right in front of their driveway. I believe it was in a cul-de-sac of a residential neighborhood, and so I believe
I'm really having trouble. Can you pull the microphone? I'm really sorry. Pull the microphone towards you.
the victim testified that he was out front of the appellant's girlfriend's house, and that he noticed her out front. So I believe he testified. I know you asked earlier, like how the duration of the assault, and he testified that he was in the cul-de-sac for approximately two minutes in the record. I believe around page 94. And so it's the state's argument that the initial assault begins when appellant approaches him with the gun in his pocket, and then ends with the victim leaving and appellant discharging the firearm into the air.
Okay, he fired the firearm in the air. Let me get to that portion of the case. He said he wasn't, if I just fire a firearm in the air, let's say I have a firearm right now and I'm looking at you,
Yes.
and I don't point it at you, I go directly up and just point it. Is that part of an assault?
If you are the focus of it, yes, it would be an aggravated assault. But if you were in your backyard or something, then it may be like a improper discharge or something.
So we have a man serving 20 years, and the man said he wasn't afraid at the time the gun was up in the air. So why shouldn't we say at the time he said he was no longer afraid, why shouldn't we say that is when the assault ended?
Well, there's no requirement that a victim testify that they be in fear during the entire duration of an assault. And I believe this court has addressed that in MMV State. And the victim did testify that he had a clear concern for his safety during the initial confrontation.
The initial part of it, before the gun was even
And there was no
going.
temporal break between the initial confrontation and then appellant discharging the.
He said, that, if I understand the record correctly, he said at the beginning, when the man was approaching him with the gun, I felt a threat. He was specifically asked at the time the gun was out, did you feel a threat? And he said no. So isn't it critical, because the firing of the gun has to take place during the period of the assault. So isn't it critical for us to know when the assault ended?
The assault ended after the discharge of the firearm and the victim drove off.
Okay, so you're, at what point was that? I mean, we're in the record to have the specific point where that cut off.
The record doesn't reflect that, but I believe the victim testified that he drove off after he dropped the grandchildren off, and then he came back later once the police were called. He was called back to the scene.
Okay. Let's get to the reasonable person standard. My understanding of the case, let me correct me. I mean, the jury talks about reasonable person. All the case law except one case out of the second district, which Judge Casanova wrote the concurrence for. Is there any other case law where a victim specifically testifies that he's not scared, where an aggravated assault, forget aggravated assault, where an assault conviction of any kind has been upheld?
In the second DCA, there was another case called Sullivan v. State where it was a police officer, and he testified that he was...
Okay, I'm sorry, I didn't complete the entire question. Where the victim and maybe I did, where the victim specifically testifies that I wasn't in fear.
Besides Sullivan v. State? I don't understand the question.
Okay. Specifically, because I just want to make sure that I'm aware what the status of the law is right now. I know there are a bunch of cases where the victim does not testify.
Correct.
And they said, we then look at whether a reasonable person would have been in fear. And according to the second district, or Judge Casanova, the Sullivan case out of the second, and I can't remember, SPM or whatever it is out of the second, are two cases where the victims did testify that they weren't in fear, where an assault was upheld, even where the victim specifically testified, I wasn't in fear.
Yes.
Based on the reasonable person theory. Is there any case out of the Supreme Court or out of this district that holds that?
There's case law in this court that for aggravated assault for the well-founded fear that it's an objective, reasonable person.
Paradise, you said? I really apologize. I'm having trouble.
It's pretty, most of the case law is that it's an objective, reasonable person standard for the well-founded fear. And it's the state's argument that under the set of circumstances in this case where an appellant engages in an inherently dangerous act of discharging a loaded firearm into the air in a residential community, that would induce a well-founded fear in any reasonable person under the circumstances, and the jury found that.
Okay.
And your alternative argument is that there was a subjective fear. I mean, there's testimony in the record that there was a subjective fear, that there was a threat. Now, albeit that was for an isolated period of time, but your contention is that there is no temporal break, there's no change in location, so we can consider that subjective threat as well.
Correct, yeah. The entire duration of the assault begins during the initial confrontation where they're arguing back and forth. And if you look at the victim's testimony, I mean, he says specifically, I felt threatened. Based on my life experiences, I knew he had a gun. I asked the appellant if he had a firearm. The appellant refused to respond. He said that he wasn't specifically paying attention to what appellant was verbally berating him about because he was solely focused on his hand motions in his pockets. So that clearly shows that he had a well-founded fear.
Why shouldn't we consider the objective threat language to be like a presumption? If the victim doesn't testify, we look whether a reasonable person would be fearful. But that presumption is kind of wiped out when the victim says, hey, I wasn't scared. Isn't that kind of, I mean, that's the argument of the other side, I would guess.
Right.
So I'm kind of confronting, why isn't that a reasonable interpretation? Because if you look at the statute, it says, you know, person being in fear or whatever it is. It appears to be a subjective test.
Well, if you look at the statute, it says a well-founded fear, and so the state would argue that that is an inherently objective standard, that it's not just fear in the mind of a person, but a well-founded fear.
Would just discharging the firearm in the air have been enough to get this issue to the jury?
Just the discharge of the firearm?
Yes.
With the appellant in the car, yes, Your Honor. The state maintains it would be sufficient evidence to survive the judgment of acquittal. For the reasons stated here and in the brief, the state asks that you respectfully affirm this decision. Thank you.
Thank you.
feel like we might have, and I referenced the answer briefs during the state's argument where they carve out Mr. Tucker's testimony regarding the time that Mr. Earven had his hands in his pockets. And specifically on page 4 of the answer brief, they carve out his testimony from the record and address what Mr. Tucker said during that time. And he doesn't say that he felt threatened at that point. He said, I knew that Earven had a gun because his hands were in his pockets. And then later on, or it's actually later on in the brief, but earlier in the record, when they're asking about, do you think he had a gun to scare you off, what Mr. Tucker says in his answer is, I don't think nothing of it. I mean, it wasn't really like the only threat that I got from him was when he walked up to me with his hands in his pocket.
Why isn't that sufficient?
Because there's no gun produced at that time, Judge. My answer would be because there's no firearm at that point. There's certainly no discharge at that point. And that makes a critical difference to the appropriate sentence that Mr. Earven winds up serving his conviction.
Well, I know the use part, but merely having a gun that's being utilized in the course of an assault, even if you don't show it, isn't that sufficient to classify as an aggravated assault?
Judge, I would disagree because that portion of walking up to the other individual who is listed as a victim at that point with their hands in your pockets doesn't involve the use of a firearm. But obviously, we find out later because the focus of the trial was on what happened later, that the individual was armed.
Okay, let's say he never fired the gun, but the victim said, I'm pretty sure it was a gun, and the way he was holding his hand in his pocket, and then he gets arrested a block away, and it is in fact a firearm.
Yes, sir.
Is that sufficient for aggravated assault?
I'd say that would be a jury issue. It would potentially the jury issue on aggravated assault, but it would not be sufficient to receive the sentence that was handed down in this case. Because,
I understand that
Yes, sir.
part. I understand, and it concerns me a little bit about the discharge occurring when there's no fear anymore. But I'm just trying, it seemed to me you were trying to make the argument that there was not an aggravated assault
Yes,
at
sir.
the beginning. And I wanted to clarify that you don't have to actually see the gun
Right.
to have
and
an aggravated assault.
I realize I'm out of time. I would be willing to concede there was a simple assault at that point that is divorced from the aggravated assault that happened later with the discharge and the display of the firearm. Thank you, sir.
Thank you. Okay, take your time getting out. I'll call the next case. Let's let the other people clear the courtroom first.